Good afternoon.
Good afternoon, sir.
Yes,
Okay, so this is company law class, right?
yes, sir.
Good. So we have 174. Maybe this is 12:36. In the next 2, 3 minutes, we'll start. Others will join. So let's wait a bit for your classmates. Hmm. So we can now start. So we are 211. It's almost 12:40, 10 minutes at least is enough to wait. Now, we at the last time, and I'm sorry I couldn't make the Thursday class because there was somewhere I had to, but I informed Mr. Lavington to help me convey my apology to your class. I want to believe he did so. So sorry once again. Now, we thank God we're all here today. Now, as at the last time we stopped, we were involved in some very interesting stuff, which your class was actually, I mean, your members are actually helping to unravel and to provide content to, which is the kind of interaction I really like. And let me say, there was a gentleman who was asking me about notes or otherwise, whether there would be notes. But as the gentleman will realize, most of what we are doing, apart from the topic, they are being provided information was being provided under my guidance to the class. The provision is basically from members of this class, which means that they are engaging the book, they are thinking about it, they are practicing about it, and they are making very useful, valuable contributions. So if you are here, seated or participating, and your colleagues are making contributions, and you do not deem it fit to at least ensure you take notes of what they are saying. And it's not more than that, it's to have confidence to understand what the law is, and you haven't given yourself time to make notes. We will formulate the notes. I'll give you material. Materials is basically grammar. And of course, all manner of textbooks you can want to consult, you are free. The topic, but in terms of what matters is your understanding and your focus and listening while you are in class, so that you can benefit yourself a whole lot more than when you are alone. So that is just my response to that. I didn't have enough time to commit to answer that. Now remember, we were looking at the powers. We were looking at the powers of the company, and I'm quite impressed when we were reviewing section 43 precisely. I was asking subsection 1, a company has the power, of a natural person of full capacity. The law has given you a formula. The power of a natural person of full capacity is what the company has, except to the extent that the memorandum or otherwise provides, in terms of that power. We'll get to capacity, so, and that is what we were doing, and everybody, or most people are contributing, useful, very valuable information for the class, and I want to believe that those who are passive will be active today. So we move on to that part. Of course, I think we were also about to look at, we were also looking at the nature of the company legislation in terms of the provision types you find in CAMA, which enables us to really unravel or unpack CAMA and make it an item that you can relate with, and then utilize it in making advice to people interested in issues really burden on company law. We identified 3 types of provisions, and as I noted the last time, this is a carryover from, or carry forward, from what we did in year 3. This is the area where you are applying it now. And of course, it is not limited to company law. Any legislation you pick up, you understand the language, the classification, and therefore the use and its deployment. If you are able to do that, then you are above a lot of problems. But if you do not know, and you just read, provisions generally, you don't understand what type it is. The type has functions. So if you don't know the type, you cannot know those functions, and they are key. And that is what makes you a lawyer, really, because your life would have to be about reading legislation, applying it, using it to advise people. So if you don't know these provision types, it's dangerous. And I want to advise that you hurry up to learn about these things so that you can at least have some peace of mind. And I did also mention that you should identify examples, 2020 each for the provision type. I even give you a hint in a particular section, and you can look at the rest of the section you ought to have read. If you indeed read them, you would have seen the types now. Giving you, when you go to section 87, you see series of, what is mandatory, enabling. And of course, I also told you to read from section 80 to 30, even to 41 or so, 42. Did you read? If you didn't read it, then you may not be able to participate, because we are going to start from there today. So, and the question will start. It is your class, it is your contribution. I am here to guide and then to see, of course, to recognize and be happy with those who get it right because they are in it. You are not in it, you are outside of it. So, CAMA comprises mainly mandatory provisions, enabling provisions, and default provisions. The mandatory ones that are there are essentially to protect public interest and also to harmonize to ensure uniformity on matters that are standard for all companies. When a matter straddles all manner of companies and their activities, whether private or public, it is likely that the stipulation will come in the nature of mandatory provisions. But where the legislature intends for companies and the operators to have some empowerment, some flexibility, then of course you can, the language will come in terms of enabling or empowering provisions. And of course the default one is the one that that sets the standard. The legislative standard is set, and it is being set because that is the takeoff point. And having set the legislative standard, which I describe as the underlying, please, just a moment, everybody. So, so once there is an underlying provision, that is the takeoff point. Now, that is where the discretion comes in. The legislature thinks that on matter that is being regulated, why it is okay the way it is has done, but because they are not familiar with people's circumstances, with the company's circumstances, one company to the other, it is important to just give them the takeoff point, which we call underlying provision. So when you have that, the empowerment will then come that you can change it, you can customize it. This is our law for you. But in case you realize that you don't like this law, change it to the one you like. Change it to the one you like. But in case you don't change it, and in changing it, they let you know how the change or the medium through which that change will occur. Are you going to use a memo to change it? Are you going to use an article to change it? You have to, there usually a specification of the medium, through which you can customize that particular one. That is why I had mentioned section 87 to you. And I want to see whether most of you or some of you who read through can underline or identify provisions that are default in nature. And of course, we can see how they apply. Once you get one, what you just need to do is to get one and then be able to look for others. And in fact, that is the hunger and the thirst. Once you understand this thing properly now, don't wait for me, don't wait for the class. You don't wait for anybody. Go get yours. You have karma living with you. Every day. You just carry it about when you are tired, open it and look for some examples for yourself because you're empowering yourself. If you don't then do that, then you are all alone. And that will be on you, not me, because I'm not your class. So that is the one. So when you and as I explained then, and I will now, a default provision is important in relationships because if there is a takeoff rule, that takeoff rule applies to the whole world, the world within the context of company now, all companies. But all companies don't have the same circumstances. So when you legislate for everybody, Just like this, your class, when somebody is legislating for you, you know, is a repository, this class, for diversity. People are different in size, you know, in height, in disposition. So one rule cannot govern everybody peacefully. So if you then realize that this particular rule is not good for you, change it. That is empowerment. The only problem is, do you know? If you don't know, you could change, and therefore you didn't change. That is where the problem is, because by the time the problem arises, you can't change it again. You are bound by that rule that wouldn't have been okay for you. But once you are properly advised and you know and understand, then it is easier for you or whoever is advising you to point out to you that, look, I see this particular provision, it may create a problem. Do you think it is ideal for the circumstances of those who make up this company? They say, no, 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 it's not. And then what do you rather we have for you? And then you suggest, and there will be an attempt, an effort towards changing. That is how you bring the law to work for you. That is how you bring the law to do what to work. So, sorry. So that is how that one works. So let's see. And as I said, the enabling one is just, and we have identified the provision types or the language of it when you are talking of may or the other one, except otherwise provides, you know, except the parties otherwise agree. Those are this will be the rule. So default types provisions have three components: the underlying rule, the empowerment to change, and the failure to change. If you don't change it, it becomes mandatory. There's nowhere else to go. If you understand you can change it, clearly you change it, and then you're at peace. You know, you have a functional legislation or provision for yourself. So now, quickly, we're not going to spend more time on this. This is an exercise that is ongoing. It's not going to finish in this class. So you may avoid talking here and think that, oh, that is it. I mean, that is it for this particular topic. I don't even understand. It is not it. That is not the end. You keep working on it. You keep asking colleagues. But because I know some of you, you know, we still make their contribution, and I've listened quite a number that have been doing very, very well here. So who can now start giving us examples of default provisions? I told you to do 10. I didn't even come last Thursday, so I'm sure you've done 40. Okay, if you know, let's go, please. If you are ready, I want to see your hand. If yes, yes. Edith Owolabi, go ahead. Just give us one. Just give us one so that, but I want it to really go through. Thank you.
Okay, sir. Sir, section 85, subsection 1.
Section what?
85, subsection 1.
Can you read it for us, please?
So let me quickly open it and read it.
And okay, and what does what classification does that fit in? You have to also guide us. You are now teaching us regarding section 81, so please let us understand you.
Okay, sorry, let me quickly. Let me see. Okay. Wait, sorry, I made a mistake. Can I just recheck it and get back to you? Sorry.
Okay, you want
But
to
it was
recall
about
section 85?
It was the section about voting where they're allowed to vote by show of hand.
Yes, I just want you to calm down. Don't rush it.
Okay,
because
sir.
you are the only person, you are the only human being now that is shining. Nobody else has the confidence to that you're even getting it wrong. They don't know whether you are wrong or right. So enjoy yourself. Just let your explanation come through. Okay, go ahead. Which one? Or do you want to share your own contribution?
Yes, I'll get back to you. I just want to
Okay, good.
confirm it. Thank you,
Now
sir.
I have Adeosun Olufunlayo Janet. Yes, this one also talks the same set
Good
of
morning.
people.
Good
Go ahead,
afternoon, sir.
Olufunlayo. Good
Good
afternoon.
afternoon, sir. Yes, section 35. It's about it says section 35 sub 1. It says unless a company
Wait, don't rush it. You are so much in a hurry. Don't worry. Let people follow you. Section 35, you said.
yes, sub 1, sir.
Okay,
It
go
says
ahead.
unless a company's memorandum specifically restricts the object of the company, its objects are unrestricted. That is, the memorandum is supposed to tell you what the company can and can't do. But if they decide not to say what they cannot do, then they can do everything that a natural person can do.
So how do you classify this?
This is under a default provision, sir.
Now, did you see? I didn't see memorandum in the thing that you're asking not to see. Is memorandum in your own?
Unless a company's articles, sir.
But you were talking about memo.
I thought it's like article of memorandum now.
Article of what?
Memorandum, is that not the full name? Article of
Uh,
association. Sorry, sir.
article is article is different from memorandum. Oh, please, it's okay, but at least I can take that. I mean, it's one of those things. I am sure you are eager to just talk, and it's good. Yeah, the classification is right. In terms of section 31, subsection 1, 35, 1. Thank you very much. So which of this section or this provision is the underlying rule? Where is the rule here? The takeoff rule, where is it?
The underlining rule is the fact is that the company's objects are unrestricted.
Okay. And where is the enablement? The enabling component of it.
The enabling component of it is where it says unless a company's article specifically restricts the object. That means
That
the
is
medium for restriction is the
so the
articles.
enablement is the empowerment to restrict. Okay? Is the
Yes, sir.
empowerment to restrict. That is the enablement. Is the empowerment to do what? To restrict. So if there is no restriction, and of course the medium for restriction is the articles. Are you getting it now? The medium to restrict is the articles. You cannot restrict by memo or any document or resolution. It is through the articles. Okay, so whereby you do not therefore restrict as prescribed, the underlying rule becomes mandatory for the company or all the companies that refuse to or do not know. So that is just it. Thank you so much, Olufunlayo. Fatu Gbagbe, yes, your hand is up. Go ahead.
Good morning. Good afternoon, sir.
Good
So I have
afternoon.
section 814 sub 1 for mandatory.
80 what?
814 sub 1.
What is 81? 81, you mean?
814 sub 1.
814.
Yes.
You are 814.
Yes, sir.
You went that far?
Yes, sir.
You want your class to hate you. Okay, go ahead.
So section 814 sub 1 is on registration of business names. And it says that every individual, firm, or corporation having a place of business in Nigeria and carrying on business under a business name shall be registered in the manner provided under this part. If in the case of a firm, it doesn't consist of the true name or four names of all the partners without any addition, Or
Okay,
in the
okay.
case of
Don't read that. We'll take it as read. How do you
okay,
classify this?
it's under mandatory.
God bless you. Under mandatory. What is the identifying phrase?
The word shall.
God bless you. Okay. Thank you. It's Edith, but okay. Let's see. Mariam Awesu after that, Edith.
Good afternoon, sir.
Good afternoon.
So I'll be reading out section 18, and
Okay.
it's under enabling provision, sir.
Section
Okay,
18.
yes, sir. 18.
Okay.
Section 1.
Can you demonstrate it? Demonstrate that to the class, please.
Okay, sir. It says section 18, sub 1 says that as from the commencement of this act, any two or more persons may form and incorporate a company by complying with the requirements of this act in respect of registration of the company. So it is an enabling act. It is saying that two or more people may decide to incorporate a company.
Yeah. Thank you. And also, when you look at subsection 2, it also empowers a person, okay,
Yes, sir.
to also incorporate. It's an empowerment to any one person, rather than keep on as a sole proprietor. You can incorporate the same, invite yourself into a company, and that is just what the law says. And it is an empowerment given to you, and that is just so. Just wanted to take the two together, subsection 1 and 2. Thank you so much. Now, Mariam, please, if you are ready now. There are so many provisions for those who are reading. You saw someone who is reading from section 814. Can you imagine? So which means the person has read from section 18 to 814, the last few days that you haven't seen me. So I'm not hearing from Mariam Akin Leke Ruth Odwayo. After that, I love Folakemi. So Odwayo, go ahead, please. Good afternoon.
Good afternoon, sir. I'll be
Yeah.
reading from section 32, sub 1.
Section 32 for what? Now, please, for those of you who are in this class, who are very silent and very, very, very lukewarm, please follow your colleagues. Make notes of their contributions. They are your teacher. I'm just guiding, and I'm happy they are teaching you well. Section 32, subsection what?
Sub 1.
So go ahead.
It states that a company shall have articles of association prescribing regulations for the company.
Yeah. Okay. What do you classify it?
Under mandatory position.
Under mandatory. What is your indicator?
Shall, the word shall,
The word shall. So it is compulsory for
a
an
company to
article
have
for a company to have. Okay.
an article of association.
Okay. Thank you. Now, let me just ask you a little bit. If you look at subsection 2, how would you deal with that? Odwayo.
Sir, what did you say,
If
sir?
you look at subsection 2, I want you to take subsection 1 with subsection 2 too. So if you are reading subsection 2, how do you classify this now? And why?
Okay. Subsection 2 should be default provision.
Can you tell us?
Because here it states that unless it is a company to which model articles apply by virtue of section 34, it shall register articles of association. So
Yeah.
what I understand this to be is that section 34 provides for application of model articles. So if the company is not a company that apply model articles, it must register its articles of association.
Yeah. So how do you reclassify that then?
So section 32 sub 2 should be default provision.
Default provision. Yes, in a way, you can say so. But the reason I picked that is that it said, unless it is a company to which model articles apply. This subsection is addressing those companies that model article does not apply to, or does not apply to. If it doesn't apply to it, then you must register. If the model article applies, you see, and bear in mind the difference between subsection 1 and subsection 2. Subsection 1 is dealing with articles. The need to have article is compulsory. It is different from the need to file an article. Do you understand my point now? Which means you can have an article without having to file one. But if the circumstances listed there or identified that applies, filing an article is one thing. Having an article is one thing. Having an article is universal. Filing an article is not universal. So this subsection is talking to two categories of companies. Those to which subsection section 34 applies, they don't have to file articles, but they have articles, and they have it by virtue of section 34. And those that section 34 doesn't apply to, those ones must have and must also file an article. That is why you still have to go to section 34 to understand those categories of companies that must file articles, and whereby you also see those that need not file an article because it is all there. So that is just it. Go ahead. Thank you very much. So Edith Owolabi, and then there is Badmus Ayomide after that. Okay, no, I say Folakemi. Okay.
Good afternoon, sir.
Yes, who is talking now?
Folakemi, sir.
Okay, go ahead.
Okay. Section 19, sub 1 and sub 2 for mandatory provisions.
Section 19, sub 1 and 2. Thank you for this calling a section.
Okay. So
Okay.
okay. Section 19, sub 1 says that no association or partnership consisting of more than 20 persons shall be formed for the purpose of carrying on any business for profit or gain by the association or partnership or by the individual members thereof. Should I continue reading everything?
Yes, now you can summarize it, but we are following you.
Okay. So it's basically the indicator that it's a mandatory provision is the word shall, and the provision is saying that when it comes to registering of a partnership or association, then that there is more than 20 persons that it must be registered. So the maximum to register a partnership is 20 persons.
Yeah.
And the subsection 2 is an exception to subsection 1, which is that the provisions in subsection 1 doesn't apply to cooperative societies, to law firms and accountancy firms, from what I'm saying.
Okay, good. You are correct. I mean, it is mandatory, but also create exceptions to that rule. Those whose membership will be more than 20, yet they can still, they don't have to incorporate a company. So that is just that. Thank you. Now, Alice, I'm liking this contribution. The only concern I have is that the same set of people that I'm hearing their voice over and over. There is Edith. Edith, if you haven't talked, go ahead. I thought you did.
Okay, sir. Thank you. So the provision for voting that I was talking of earlier, I made a mistake, is actually section 248.
248.
Yes, sir. Subsection 1.
Okay.
And it's actually a default position. So it says at any general meeting, a resolution put to the vote shall be decided on a show of hands or electronic voting, unless a poll is demanded by blah, 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 blah. So, sir, why is a default position is that if the article of the company is silent on what to do as regards voting, they can apply what has been provided here in section 248, subsection 1, that is by the show of hands. But if the article of the company has already made a provision for it, or if they decided to follow subsection 2 that speaks on poll, if the members of the company decide that they want to use a poll, then they can use a poll or follow what's in the article of association of the company. But if there is nothing said on that, then voting can be done by a show of hands.
Okay, thank you. Now, to the class, at any general meeting, a resolution put to the vote shall be decided on a show of hands. That is how generally you make decisions. You show your hands, unless a poll is demanded by the category of people listed thereunder. So, in case there is no poll, then deciding or making decision by the shareholder will be by show of hands. But once a poll is triggered, before or on the declaration, because even when you are going to use the poll to override the show of hands, because when you don't want the show of hands, what you want is the show of your shares. Because if you are showing hands, it's equality. Everybody has one vote. But if you now say, no, this is a very important, it's an half, enough swag in terms of your percentage of shares, then you demand for a poll if you qualify, and it will automatically revert to people voting by their shares. And so we shall see who really has the power inside the company or not. So that's what it means. Thank you. Yes, I will take it as default because the rule is there, can be changed by a poll at the right time, and the medium is through a poll before or on the declaration of the result of the show of hands. Okay, so you can time it and then trigger it and override the show of hands into something else. So that is that. Who else is next? Thank you, Edith. Yemi Adedeji. What about Badmus? Have you?
No, I'm not.
Okay, well, quickly, please. And then after you, Yemi. After you, Mofeola.
314 and
I can't hear you.
Can you hear me, sir?
No, not yet.
What about now, sir?
I'm hearing a little bit.
Section 314 and
It could be
section
better. I want you to, you are not shouting at this thing. We need to hear you. Not too many people talk, so.
What about right now, sir?
You are now answering your name. Go ahead.
All right, so I was saying section 314 and section 315 can be said to be a default provision. So I'm reading from section 314. It says, in a limited company, the liability of directors, managers, or managing directors may, if so provided by the memorandum, be unlimited, which means in a limited company, the powers, the directors can be made to have unlimited liability.
So how do you classify that? How do you classify
it's a
subsection 1?
It's a default provision, sir, because it's a default provision, sir, because it said if provided by the memorandum, which means if the memorandum does not provide for it, then the liability remains limited, and that becomes a mandatory provision.
Very good.
Then if the memorandum provides for it, then you have the choice to use it. Then 315 now talks about the resolution, the powers of the company to to have a resolution on how the director can have unlimited liability. It says a limited company, if authorized by its articles, may by special resolution alter its memorandum so as to render unlimited the liability of its directors or managers, which means if the article provides for such resolution, then the company could, by that resolution, make the liability to be unlimited in a limited company. So if they take such steps, then they have that power. So it can be an enabling provision if they take that initiative, then they have the power to make a limited company, or to make the liability of a director be unlimited in a limited company. So they have such power. However, if the article do not provide for it, then it stays mandatory. So I just classify it as a default provision.
Thank you. Really, you have taken on a very complex provision that requires some comportment to understand. but that you actually decided to go, to give it a go, it's a credit to you. What I would advise you do again is that after the class, sit down, properly and go over section 314 and 315. We are going to discuss that in the course of this class and see whether or not you want to look at what exactly are the rules if the rule doesn't come up. Sorry, what is the underlying rule? How are companies empowered to run away or change the underlying rule? So if they don't change it, what exactly is that rule that becomes mandatory? And see how the medium of changing it, what is the media for the two to change from mandatory to the one you customize for your own benefit as a company. Those are things I want you to go over. It's a little bit, it's good because it's very challenging and it's a way to really test your capacity to handle some of these things. Some are straightforward, some are fairly complex, but all said, they are doable and they can be understood as well. Thank you. Mofiola.
Section 87. It says, Section 87 sub 1. It says, a company shall act through its members in general meeting or its board of directors.
You are so cool with 87 as if you wrote that particular section for government. Okay, go ahead.
Okay, so basically, it's talking about division of powers, and it's a mandatory provision because of the word
Which one
shall.
are you doing? Which one
87 sub 1.
Okay, so how do you classify this?
It's a mandatory provision that the company shall act through its members or its board of directors. Then Section 88 says,
don't go to don't tell too many people. At least you've done one for us and and
okay, I just wanted to give one default and one mandatory.
Aren't you kind? Go ahead.
Okay, Section 88 says, unless otherwise provided in this act or
88, right?
Yes, sir.
Yeah.
Unless otherwise provided in this act or in the articles, the board of directors may. So with the word of may, it's enabling them to decide.
Go ahead.
So
go ahead. Yes, I'm following.
Section 88 has two parts. The A part is they may exercise its powers through committees consisting of such members of their body as they think fit, or from time to time appoint one or more of its members to the office of managing director and may delegate all or any of its powers to such managing director.
So you classify it as what?
Default, sir.
Fantastic. So that is it. You can see class, this person not only give us one and then also give another one for free. So that is how it should be. Thank you. You are correct. Again, look at your provisions properly. Go by it. In your classification, they are correct, really. Okay, you are correct. Both 87, 1 and 88, they are correct as we classified them. Now, Oluwapelumi, I have not seen too many. I have not seen more up to 10 people since we started. Are we up to 10? So yeah, let's rush it a little bit.
So section 20.
Section what?
20.
Okay.
It's a mandatory provision which
Section 20.
Sir. Prescribes prescribes who can form a company. Describes the criteria for individuals who can form a company, and the use of shall makes it compulsory. Where it talks about the individual must not be less than 18 years old, must be of sound mind, and must be an undischarged. Must not be an undischarged bankrupt order, and must not be disqualified under sections 281 and 283 of the Act.
Yes, that's true. Section 20, subsection 1, that is correct. Thank you. Now, you see, sometimes, let me just also inform the class, sometimes that subsection 1 comes out as mandatory, it doesn't mean the next subsections or the others are the same way. They may be different. So please, I want you to also note that and bear that in mind. It's very important, okay? So Abigail Omoyele, your hand is up, and then Oluwatosin, and of course Toluwani. Yes, Abigail.
Okay, sir.
Quickly.
Section 430, subsection 1 and 2. Let me read it. So it says the directors may, before recommending any dividends, set aside out of the profits of the company such sums as they think
400 proper. And what? Sorry, what? 402,
430.
Right? Okay.
Should I go ahead, sir?
Oh, sure.
Okay, so it says that they may set aside out of the profits of the company in such sums as they think proper as a reserve or reserves, which shall at the discretion of the directors be applicable for any purpose of which the profits of the company may be properly applied, and pending such application may at the discretion either be employed in the business of the company or be invested in such investments or other than shares of the company as the directors think fit, and the directors may, without placing the same to reserve, carry forward any profits which they may think prudent not to distribute. Okay, so because of time, the same thing is it's, first of all, I classify it as enabling provision because it gives them the power to make that decision, like to set aside the profits of the company. And then subsection 2 also is an enabling provision. So the word may is what gives me that idea.
That is correct. Now, the 2 is correct. Thank you. The fact that you even have the patience to read this kind of bulky stuff and still be able to identify what exactly people or companies have been empowered to do is also a credit. That is just that. Now I would take, I thought I would not be able to exhaust a lot of people whose hands would be up, but obviously there are not that many. So I will take 3 more and then we move to the next section of this class. Let's see. No, I call some names, they are gone. Adetola and then Chizom.
Okay, good afternoon, sir.
Yeah.
So section 22 sub 2 states that subject to the provisions of the articles, a private company may restrict the transfer of its shares and also provide that the company shall not, without consent of all members, sell shares that are more than 50% of total value and so on. So this is an enabling provision because the private company can decide to restrict transfer of its shares or not.
Okay. Although the empowerment to restrict transfer is subject to the provisions of the article. So what it simply means is that a private company is empowered to restrict, the transfer of its shares and also do some other things. But if the restriction of that transfer is to be guided by some other regulations, that is where the article comes in. But the empowerment, therefore, they are originally is to empower empower company to restrict, the transfer of its shares, if it's a private company. Yeah. So I hope you understand it.
Yes, sir. Thanks, sir.
And then there's also an empowerment to make certain under provision and also provide that. So ABC, there are the other things that can be done, which private companies are empowered to also do. So Adetola Rukaya Oluwatosin. Yep.
Yes, sir. I was the one that just spoke.
Okay, sorry.
Yes.
Where
No
the
problem.
Chisholm? There's one. There's Chisholm.
Yes, good afternoon, sir.
Okay, good afternoon.
So I wanted to talk about section 43(2) that prohibits a company from corporate political activism. It prohibits the company from participating in politics by donating any of its assets for political purposes. And the consequence being that the officers that are in default will be liable jointly and severally to refund the sum of the value to the company.
Okay. Thank you so much. Thank you. So the last person on this. So now 43(2) is, how do you categorize this?
A mandatory provision.
Very good. This is a mandatory provision, correct? Thank you. Now, who else is the last person now? We're going to touch even on that 43(2) before we move. Okay, with the last person, all these other ones have spoken. If you have not spoken today, can you just, okay, Toluwani.
Yes, good afternoon, sir. So I wanted to talk about section 318, which subsection 1 provides that every company shall keep a register of its directors. So it's mandating every company to keep a register of its directors.
Yeah, okay.
Also, sir, I wanted to ask a question concerning what Ruth talked about earlier, section 32, subsection 2, where it says unless it was following up on section 32, subsection 1, unless it is a company to which model would apply by virtue of section 34, it shall register articles of association. And you were talking about that there's a difference between having and then I didn't really understand that part that you were talking about. Between having
have you read section 34?
Okay, not exactly.
Until you read section 34, you may not be able to get it.
Oh, okay. But I wanted to ask, is it a default provision or is a mandatory provision?
You see, you know, which one now? Section what?
32(2).
Okay, read it out. Let's see.
Unless it is a company to which model articles apply by virtue of section 34, it shall register articles of association.
It's mandatory. Is it unless it is a company to which model articles apply by virtue of section 34, it shall register, you know. That is, if you are a company, simply, if you are a company and that and model article doesn't apply to you under section 34, you must register, you know, an article of association. It's compulsory for you to do so. Okay, so the only reason why you will not register is because section 34 applies to you. And as I also made mention, that there is a difference between, you know, having an article and registering an article. Section 32(2) is speaking to us about registration of article. Having an article is compulsory for all companies anyways. The type of articles you have is what the issues is about. Are you going to rely on model articles or you just have to file your own articles, okay? So that is just it. Now, thank you everyone that have made contribution. And you can see that for those who really have taken time to look at this in the course of time, they are able to speak. I'm worried about the number of people that are raising up their hands. We have 290, we are dealing with 300 people or more, and I'm getting just about 10, 15 people. In fact, I should be begging you guys to lower your hand. And then what we have is that I'm actually clamoring, you know, asking where are they? Where are they? I can't find anybody. So enough people. But that is just it. And it the notes is in practice. It's practical, it's clinical. It is only those who are, you know, toiling and who who are making the effort, who don't care getting it wrong, who want to know, and therefore are reading ahead of time to know which example they too can give. They are the ones that can know. For the rest of us, it's speculation. And you never can tell how this one is going to come, because we are at the realm of application of these provisions now. So maybe you will be focusing in the course of time more on the areas that we touched. Now, the last time, let's tidy that up. We are discussing power of the company. So for the discussion we've had on section 43, and I think we had very wonderful section 43 analysis. Now, there is a particular aspect of section 43, and I want you, everyone, to go to section 43 again, so you can see that there's a scale that needs to come out of your eyes, so you can see a bit clearer. Now, I want someone to read it for me among those who have been talking, or if you have not talked at all, maybe you can lend us your voice to make contribution. Oh yeah, anyone?
Sir, section 43 of what?
One.
From the beginning. Okay. The heading is power of companies prohibition of donation for political purposes. Sub 1. Except to the extent that the company's memorandum or any enactment otherwise provides, every company shall, for the furtherance of its business or object, have all the power of a natural person of full capacity.
Okay. Now, how do you classify? Let us start with that. How is this one classified?
I think it should be a default provision.
A default provision. What is the underlying rule?
The underlying rule is that every company shall, to the furtherance of its business or object, have the powers of a natural person. That's the mandatory. That should be, yes. And now that should be the mandatory rule.
That's the underlying rule.
That's the underlying rule. Then the enabling rule states that the company
the enabling component.
Enabling component of this section is that the company shall, by memorandum of or other enactments, provide otherwise, maybe to limit its powers.
God bless you. God bless you. I know that's correct. Okay, you can see it is not always easy when you're on the spot answering. You look fairly shaky, but because there is intent and there is knowledge, you are able to put through, and you get it right. That's correct. Now, you see, what I want you to note, the class to note here is this. This part of the enablement portion of it. It says, except to the extent that the company's memo or any enactment otherwise provides. So block that one out. This would what the company is being empowered to do. Block it out as if it's not there. If you have your pen yellow, just mark it yellow to up to provides. Okay. The rule here is every company shall, that is the power of a company, which is that of a power of natural person of full capacity, shall, for the furtherance of the company's business or object. That is, you can only use your power for the furtherance of your business or your object. However, if your memo so provides, you can use your power as you want. That's your power of natural person of full capacity. You can use it as you want. As you want. But if the memo doesn't urge you or permit you, what you are left with is that all this your power of natural person of full capacity can only be for the furtherance. So if you then, in the gap of exercising the power of a natural person as a company, the question may therefore be that is the power you are using going to further your business or your object? Will it? If the answer is no, then what you are doing is not authorized. What you are doing is not authorized. And so you must, so for the company that wants to deploy their power, sometimes to do much more than just focusing on the company or furthering the business of the company, you have to use the memo to free yourself. And then bear in mind that it is not every power you exercise which may further your business that have to relate to the business itself. If you are selling merchandise and then you are giving extra stuff to customers in order to build your market base, although it would appear that you are losing money, you are wasting it, but the long objective is to actually build a market base for yourself so that in future, your customers could identify with you favorably, and then you can capture that market. Remember that originally when, I don't know whether where everybody was, when Glo started, Glo was the network that started the per second billing, where they're not charging for, because then if you make a call, or if you made a call and by the second of the minute the call drops, you are charged for a minute, and people are losing money. But Blue said no, we will start to bill per second. So if you use your stuff to 15 seconds and you cut off, that's what you lose. You don't lose a whole minute. So again, Glo was losing money on the face of it, but because it's directed towards customers, to be accountable for their minutes, their seconds, so that they don't lose enough money. Ultimately, Glo won a lot of customers. And when the other competitors of Glo realized that Glo was really, turning the corner, they joined. It was Glo that forced the network's hand to start, doing pavilion. I don't know what they are doing now, whether it's still pavilion or they are still deceiving us. Times have changed. Because they have made money now. Everybody, all of them are rich, seriously rich. It does not matter anymore. What we do is not their business anymore. So, because now we are hooked. Can you imagine now not having a credit, opportunity to buy a credit for one day? All of you will go gaga, because it's like, some people have tied it to their lives that bad. So the demand for calling credit is inelastic. In fact, some people can steal it if it's possible. Or what do? They even borrow. They incur debt because there is inelastic. It has become something you depend on. And when you are hooked to a particular activity, how do you describe it? That's the word that is used to describe something you are hooked to doing at all time. Conscience. What is that word? Addiction. Addicted. All that addicted to those kind of things. So, all I'm trying to say is that if you want to give yourself free space so that you can do a lot more beyond just furthering your business, you can utilize your memo to give that space to yourself. Okay. And this is where we sometimes, as lawyers, corporate law lawyers, engage ourselves in asking whether things that are done to society, to the environment, to motherless babies' homes, and to help them, or those who suffer from displacement because of war, yes, they are not getting back to the company. But is it to further the business of the company? If the answer is no, then, and you are doing it, you are violating, you are misusing that power, and then you may be liable for that misuse. But if it is something that has some connection with what you do, then of course it's legitimate. So that is what I want you to bear in mind. In terms of what that power means, we have seen a lot of examples last week. Now, the other part of this is the subsection 2. And I'm happy the last person, or near the last person that spoke, picked that particular subsection 2. It's a spirit-led, because it is one of the things we need to discuss. This is the power, or I mean, this is a subsection that also curtails. So whatever the power the company will have, it cannot include the subsection, the subject matter of subsection 2. And that's why the person said it is a mandatory provision, because it's forbidden. A company shall not have or exercise power, either directly or indirectly, to make a donation or gift of any of its property or funds to a political party or political association, or for any political purpose. And if any company is in breach of that subsection, makes that donation or gift of its property to a political party or association, or for political party, the officers in default and any members who voted for the breach shall be jointly or severally liable to refund to the company the sum or the value of the donation or gift and all of that. So now, you are forbidden from doing so. Interestingly, I want you to also go see, let's see now, section, is this section 221 of the Constitution? Okay. Now, so I want you to also go read, you have to read section 43 subsection 2 alongside section 221. It's important you read it that way. No, and I know you don't have your constitution here, but let me read it for you. It says, no association other than a political party shall canvass for votes for any candidate at any election, or contribute for the funds of any political party, or to the election expenses of any candidate at an election. Okay? That is that one. No association. Okay. No association other than a political party shall canvass for votes for any candidate at any election, or contribute to the funds of any political party. Okay, now I want you to also, okay, First Amendment, okay, that one has been deleted. So they're talking about association. The original one, this one has been amended now. So they have limited it in their definition of association before, included a company. So that is just it. Now, but I want you to go to the Electoral Act of 2021. I want you to see, for instance, the power that is conferred on persons or entities, to make political contributions. Now, and I want you to link it to section 43, subsection 2, and see if they contradict one another. And in case of conflict, how is that to be reconciled? So it is very, very important. Now, when you are talking about a company shall not, have power exercise to make a donation. Now, if you are not making a donation, because to make a donation means that you are giving your money to somebody, but can you or gift of any of his property or funds to a political party or political association or for any political purpose. If any. Now, the question is that I want you to ask is this, that I want to ask you is this. Companies are persons, and what companies do affect a whole lot of us. And they are, and of course, government regulations also affect companies. So suppose a company wants, recognizes that election season is here, and they are pressing for a particular right or the promotion of the fund or some fundamental rights. And to that extent, they are creating sensitization, of the people, on the importance of that particular one, but they are not giving it to any association also. How do you want the companies to remain quiet, silent, when you know that most of these laws actually affect them? I mean, look at the law that is on now, the tax reform bill. It affects companies positively, some badly, and you want them to keep quiet. You want them to keep quiet. Is it sustainable in these modern times? Most companies or countries I know, UK, Australia, Canada, US, they have rules on what to call, this corporate political speech. That is what they call it. Is it possible? So they have provisions whereby they have recognized that it doesn't make sense to ban companies from being politically active, because if they are not, they will be dead. Most of the things that happen affect them. So how do you want them not to be proactive? It's senseless. It is senseless. You can regulate, you can subject, because the fear of those who enacted this one has been in our law since 1990, Kama 1990. The fear was that if you allowed them, they could use the money, those directors who have power and control the company could use the revenue or the resources of companies to fund political parties. And that was what was the case in the Second Republic before those companies, leaders were put out of power. And then by the time the 1979 Constitution came, they recognized the need in the 1990 to curtail the power of companies, using the power of managers using companies' money to fund political purposes. That is the reason. But times have changed, because a lot of companies that are in place also come under the hammer of legislation. And those are compliant with those legislations seriously. Some of them are very expensive. So how do you want this to continue to happen? It is not like that in other countries. They are regulating it. So I want you to look at how Canada does this, how Australia does this. I don't want to go to US. It's a little bit more delicate or more complex. So but what I want you to turn your attention to is that look at the Electoral Act recently, see the permission given to companies, and then compare that with the Section 43 subsection 2, and then see which of these laws do you think is sensible. Do you think is sensible? There is Bakari. Your hands have been up for quite some time. What do you have for us?
I wanted to ask if in the Electoral Act, is there a particular section you want us to look at, or just like a general overview of the permissions given to companies?
As a year 5 person, yes, there's a particular section. But as a year 5 person, how do you find section? How? Tell me. How do you find sections? You need somebody to guide you how to go and find sections. And then you should go and look at it, which means it's there. And you're asking me how to open it. So okay, you will start opening it one by one and be looking at it one by one. Abi, tell me, how will you get it? You know the answer.
Well, I'll go
I'm
online.
listening.
I'll go online to
Or is-
Google provisions of the Electoral Act that relates to companies.
You will go online to first of all download the Electoral Act. When you then get the act, where do you go to look at what you need for yourself? Because it's not every part that is relevant. Auntie, tell me. I want you to tell me, you know. Oh yeah, because if you don't know, that will really hurt my feelings. Oh,
I
yeah.
don't know the section, no.
You don't have to know the section. They've told you that it's in a book. It's a law. Once you know that is it. That's what you need. That's the lead you require as a year 5. You're not year 1. So somebody to tell me, where do you go?
Hello, sir. Hello, Prof. Table of
Yes.
contents, sir.
Huh?
Table of contents, sir.
God bless you. God bless you. Oh, God bless. Table of content. That is it. Thank you. So, and then you are now trying to shout it at me that it's table of content. Once that guy had given you an idea, it is the table of content you check, okay? It's there. You have to learn to do things for yourself now. You are big people, big madam, big men. So and you must take care of yourself. You are able. So don't be lazy or be waiting to be spoon fed, because this idea of online is even good. You can see a lot of you are dodging me, so I cannot call you. But you have to read yourself. That is what it means. And I'm happy that at least a tangible number are very active here. Although I want diversity. I'm not happy about this. Now, the next we are going to be looking at now are because once you incorporate a company, there are some documents that you must file. The critical part of those ones are the articles and the memo. We want to start looking at the nature of articles, the nature of memo, the contents of memo. The contents of memo are so key. And don't ask me where you find content of memo or article in Kama again, please, because it's there, table of content. In fact, if you had read most of the sections that you are asked you to read, you would have been familiar with. In fact, you'll be waiting for me. And so I want you to read the contents of memo to start with. Understand those things that must be in memo, because we are going to use it for serious analysis. But you must know. We are going to take most of those things one by one. And then the articles, how do you compare the articles with with the memo? What is the relationship? Do they have some, supremacy issue? I hope you are noting what I'm asking you. You need to familiarize yourself with the contents of articles and memo. That's number 1. Number 2, you also need to examine the questions of supremacy. Is there a supremacy issue between the articles and the memo, or they are documents of equivalent relevance and power, and stuff like that. And then what is the purpose of the memo anyway? What is also the purpose of the articles? In some countries, they don't call it memo anymore. They just refer it as constitution. So the constitution is what they regard it to. In fact, UK, in their Companies Act of 2006, they have done away with memo. We inherited memo from them since 1856, but they did away with it in 2006, and we are still hugging our own. You don't have memos anymore. What do they have? They just have articles or constitution. They even use the word constitution, and they define it. If you go to section 8 and 8, 9, and 10, you will see. You won't recognize what memo used to be the marquee document, the major document in incorporation, where they did away with it. In fact, there are only 2 clauses in it, very irrelevant clauses. Now, so they relegated memo to the dustbin of history, except for 1 or 2 issues. So now the focus is on article and stuff like that. So, but our memo, we still retain memo, whether consciously or unconsciously. We retain memo. When next we are discussing this, then it is for you to now make up your mind. What informs our, retention of memo? Is it out of deliberation? Were we intentional, about the retention, or we just didn't? We just got confused and we just left it that way. Okay. But there are things that the legislature was doing regarding memo and articles that looked as if they were panicking, they were not so sure what they were doing, and stuff like that. So we're going to look at that. Then for the articles, though, articles are in the company's regulation of 2021. You can get that. The articles is in the schedule section, schedule 20 or 21 or 22. There's one for model articles now for private company, the other one for public company and stuff like that. So is there, and again, how do you get that? You get a copy of the company's regulations, in online. And once you have it, I have my own, and it's online, it's in my system. So if I need it, I go through it, but I don't find. So, but there, that is how you should do. It's not for me to get this because it is gettable. So once you start looking at it, you begin to learn some of those things that you find in the regulation, in the articles or model articles. And of course, section 32, section 34 also tells you the status of articles. There are regulations for the company. They are particularly useful. That is the articles to regulate the intra-corporate relationships, meaning those within the corporate, entity, shareholders, directors, managers, everybody. They regulate themselves, those that intend to come in. And that is why Section 46 also becomes essentially important. So part of what you're going to read before you come to class is also Section 46. So we're going to see those, and of course the ones for memo. You also go through it. Look at what the act says must be in the memo, and then we start discussing the implications of what we have there, and then now we can reconcile some confusion, and then put everybody, on a good state to engage discussions on this. Okay, so I guess this is a good place to stop. Don't forget to read this material, these provisions of the law. That is your primary stuff. And for those of you who have been speaking in class, I want to thank you again. It is good. Grace gives us a lot of meaning. For those who are still very, very quiet or who still don't care, they are reading ahead. Time is going. Before you know it, you'll be doing a continuous assessment. So please do your own part. Don't wait. Do your own part. Speak, read, make contributions, whether you get it right or not. It doesn't matter. If you are wrong, we correct it. Some of those who spoke today were corrected, but they're better. So that's justice. So until Thursday, have a very wonderful day and time. I will be here to continue our discussion. Have a very wonderful day. Okay? Bye.